for the torture and the likely war crimes committed by the previous administration in our names, torture that has been proudly, repeatedly, and recently trumpeted by former Vice President Cheney. The door may now have been definitively and completely shut by this administration. The breaking news at this hour, the Justice Department has completed a 2-year review of Bush administration lawyers who authorized interrogation techniques such as waterboarding, and going against the finding of its own investigators, has concluded that the only thing they were guilty of was poor judgment. The lower level enabling functionaries who should have been just the beginning of a proper reckoning are now off the hook, like Bush-era Justice Department attorneys John Yoo and Jay Bybee and Stephen Bradbury. From the Justice Department, led by Attorney General Eric Holder, in a conclusion made by a senior career official, those 3 attorneys showed poor judgment. That was a downgrade from the harsher finding that was made by DOJ investigators, that investigation having arrived at a finding of professional misconduct. Put some of this into perspective. The investigators' finding of misconduct, even if it had not been overruled today, may have amounted to little more than disbarment for those 3 Bush-era lawyers, but today's finding says those lawyers did not even violate ethics rules. The same 3 men who actually carved out so-called legal standards for the interrogation of high-value detainees, torture. The DOJ report now says that these men, quote, exercised poor judgment. Let's turn to constitutional law expert, George Washington University professor Jonathan Turley. John, good evening.
Hi, Keith.
So this was just bad legal advice?
Well, obviously it wasn't. They're saying it was. I mean, bad judgment is when you make unfortunate choices in dinner guests. It's not when you support a torture program. And what we're seeing right now is the dismantling of precedent that we created at Nuremberg when we said that you can't facilitate war crimes as lawyers and say that it was simply bad judgment. Everyone who commits war crimes often thinks about their own accountability. They often go to lawyers to facilitate them. That's why they were so critical at Nuremberg. And what we're seeing now is that we're just treating it like it was just a bad day. And it's more than that. But what we're losing in all of this is one of the core principles of Nuremberg.
So the next George Bush with the next Dick Cheney with the next Don Rumsfeld, and go down the list to the next Bybee and you and the David Addington, whoever that is next, whether it's 10 years from now, 2 years from now, or 100 years from now, looks back on this and says, oh, all right, so somebody will later call me guilty of bad judgment, and that will be it.
Keith, you said the exact problem, and that is if you can't be held accountable for facilitating war crimes, something that they don't really discuss in this report, then when can you be held accountable? I mean, this is it. I mean, this is the worst case scenario. And so what the Justice Department has done is carved out for itself a standard that it can never fail, that even supporting torture is just bad judgment. In this report, it's astonishing what you read with Bybee, who is a judge, who's sitting in judgment on others right now, is accused in this report of just leaving out critical cases, of leaving out weaknesses. In one case, he said he just assumed Gonzalez would know about the limitations of this type of executive claim or the limitations on a good faith defense. He just assumed he'd know that. And instead, they produced this report, which was a roaring endorsement of torture. That's being treated as, in the report, as, quote, incomplete legal analysis. It's not incomplete. It's willful blindness. It is an attempt to defend a flawed legal theory to support a torture program.
An error of commission is sanitized into an error of omission under those circumstances. Right. You mentioned what is not in this report. It's 300 pages. It includes emails among the Justice Department and the White House and the CIA. Is there anything in it that at least gets us to understanding what happened in the Bush administration that established torture as acceptable?
Well, a lot of it will be particularly interesting to law professors and legal experts in the extent to which people like Bybee, who really comes off badly in this report, left out critical pieces of precedent where he was aware of Supreme Court cases that go the other way, and he just leaves them out of the memo. In one case, they rely on language in the United Nations Convention Against Torture that was never ratified, and yet they treat it as if it were. I mean, that's the degree of misrepresentation that is in this memo. And yet the Justice Department really doesn't deal with that, and it does certainly not deal with what they're doing with the Nuremberg standards. Instead, they just say that, you know, they're wrong, they're incomplete, they're showing bad judgment, but that's not something that they should necessarily be punished for, even though people were tortured as a result of their advice.
So if you put this back into history and applied it directly to Nuremberg, the finding about the German judiciary system of the 1930s and 40s would have been what?
Well, they could use this, if this report existed back in Nuremberg, it would have resulted in acquittals for all of the people that we sentenced. But this is a bloody nightmare for civil libertarians. We have an ex-vice president who's proudly proclaiming how he supported torture. We have a current president who is preventing any serious investigation of torture. If torture is so bad, imagine what it's like to try to protect alleged torturers, war criminals. And that's the really dark period we're finding, where we're all wondering, where did our principles go?
And the news comes out on Friday night. Jonathan Turley of George Washington University. Great work on this subject. I hope we're not done with it. Thank you, John.
Thank you, Keith.
Meantime, the former conservative congressman from Georgia, Bob Barr, went to the conservative CPAC convention and told the conservative crowd that enhanced interrogation was torture. They booed. On the other hand, when a young conservative condemned CPAC for including gay groups, he was booed. The party of boo ahead.